trying to pretend, and this is a good bridge into the Rumble versus Google claim, what big tech still hasn't woken up to. Because what happened is big tech used Section 230 to mean something it didn't mean by interpreting it to say to courts, this is the politicians are on our side, so you better be on our side too, and just expand its definition to give immunity for almost everything and don't apply its plain language anywhere. Then they bought off most of the legal academy. Most of your law professor types who claim to be independent tech people are really just grifters or just prostitutes for big tech. That's all they are. If you dig into where they're getting funding for a wide range of things, who's their side clients, etc. So they're not accustomed to ever losing. And when you research the background of these big tech execs and the big tech founders, they're mostly people who've never lost in their lives. So they don't know what it means to lose. And they have grown very arrogant and completely disconnected. Part of what they've been doing is building their own echo chambers now for a decade or so. And the net effect of it is they don't realize that politically is that a lot of these decisions that were made by courts were political decisions, not really legal decisions. So an example of that is once the Department of Justice and all of the state attorney generals, or a bunch of them, started filing antitrust claims, that meant the courts were no longer going to look at those antitrust claims the same way involving big tech. That's why it's unleashed a flood of antitrust cases, of which Rumble is just the latest against them. And they've been doing things, as Matt Stoller and others have noted, and he's from the left, but he's a good antitrust guy, is that things like tying are classic antitrust violations. And even though the Rehnquist, a lot of Republican Supreme Court justices have undermined antitrust law over the last 20, 30 years, one place that's still vibrant is what they call tying. It's when you use your monopoly to create an economic advantage in some other area. And that's what Google's been doing that en masse, but that's what YouTube was all about.
Well, so here, let's get into it, and I'll give the 30,000-foot overview. Rumble, everybody knows now, is it's a small version of YouTube. It's competing, and it's doing well. It's called the free speech YouTube. It works the same way. Creators can upload, they can monetize. CPM, cost per mil, is competitive with YouTube, if it's not virtually the same. And it was cat and dog videos. It's been up there since 2013, but now it's sort of been the recipient of the purge from YouTube. So it's got a lot of conservative voices. Dan Bongino, Dr. Srinivasan, I think. A good doctor, Dr. Shiva. Okay, so now they have been trying to gain ground, and they've been gaining ground. They have just sued Google, alleging antitrust, and we're going to get into this because there's the Sherman Act and there's the Clayton Act, and I don't exactly understand how they work together, but I think I do, but we'll get there. They're suing Google for antitrust violations in that Google, which owns YouTube, which is owned by the umbrella company Alphabet, apparently tweaks the Google search engine to favor and prioritize YouTube search results to the detriment of other businesses. And so Rumble, which... it's a little complicated. I'm going to go through the lawsuit itself sooner than later. Today was just an overview in my vlog, but basically Rumble owns exclusive rights to some videos. They then syndicate them out to syndication partners who then run them on Yahoo, MSN, and YouTube. And the revenue that generates goes back to Rumble and for their clients. That's the syndication process. Rumble, which has exclusive rights to certain videos, once it publishes them on their syndicate partner platforms, sees that all of a sudden they don't even rank in the search engine, not for the search term of the video, but for the actual metadata of that video. So they upload it to Rumble, and then they syndicate it to MSN and Yahoo. This is from the lawsuit. They notice that in the search engines, it'll come up Yahoo, MSN, and I think Rumble as well, but not YouTube because YouTube doesn't have the video yet. Then they syndicate it through YouTube. Instantaneously, before the internet has collected any data, YouTube comes up as the first search result for the metadata, not for search terms, and Rumble doesn't even appear on the search results. Or if it does, it's after the 9th one, which is effectively not there. That's the overview. And so Rumble is now saying that this has cost them $2 billion in that they have not only been denied search results based on a skewed and trying to not use inflammatory words, but a falsified search engine which favors YouTube. It's like Google saying, hey guys, go to our other place, but not telling you this because that's the number one search result when it isn't. And so they get the financial rewards for that. They get the traffic, which stays because once you go to YouTube, on average, apparently you watch 9 to 11 videos. That would have otherwise been revenue for Rumble. And so they filed an antitrust lawsuit, and it's great. It's interesting. See where it goes. Did I miss anything in the summary, Robert?
No, that's pretty much it. I mean, basically what Google did is Google bought YouTube, and then they did what's called tying, which was using their control over the monopoly they have over searches. I think it's 93, 94% of all searches are done on Google, that use their monopoly on Google to what's called tying to allow to increase profits for YouTube, a separate business or enterprise that Google now owns. And that aspect of tying is precisely what got Microsoft into trouble with trying to leverage their control over operating systems to force feed people to use their web browser rather than Netscape. And they ultimately lost. So tying is one place where our law has stayed strong. My own view is monopoly law was meant to prohibit monopolies, period. And this extra tying requirement was all superimposed by, frankly, conservative Federalist Society type judges who gutted antitrust law for decades. It's one area that, a lot of on the new populist wing of the Republican Party and conservatives don't realize how much the corporatist wing has done damage and favored these monopolists for forever, really dating back to the 1900s when they didn't agree with Teddy Roosevelt on it. So Teddy Roosevelt had to fight the corporatists in his own party to even pass any basic antitrust laws, where all these laws come from. So, but putting aside for the moment that aspect, tying is clearly illegal. That's clearly what Google is doing. They have example after example after example of it. And what they had is they have 3 nice claims. One, that tying is recognized as illegal antitrust violation under both the Clayton and Sherman Act. Second, though for different reasons under each statute, but that's what it boils down to. The second component is giving real-life examples of how that worked and showing it to the court so the court can see it and witness it right within the complaint. And third was excellent citations to remind the courts that the politics has changed. Number 1, citing the Justice Department's own antitrust complaint. Number 2, citing the House committee's conclusions that included Democrats about the problematic antitrust monopolistic behavior of big tech. And so if I'm a judge, I see a very different political environment that, frankly, Facebook and Twitter lit on fire by canceling the president of the United States while he was president. So they clearly, they don't take seriously the antitrust claims against them, just like Bill Gates did. Bill Gates didn't take it seriously until he was about to lose. It was his complete disaster of a deposition performance, where David Bowie's actually did a very good deposition of him, that started to enlighten him to the reality of it. And he later admitted it did a massive blow to Microsoft's ability to dominate that area of space that it planned on dominating, and believes it would have, but for the antitrust claim. These antitrust claims have from the Justice Department and the state attorney generals have a very good chance of going forward, even if the ship has sailed and the Biden Justice Department being able to pull it back, because state attorney generals have joined it and it will look really bad at this stage. And big tech thinks because they'll have a bunch of cabinet positions that now magically these judges will still go in their way. And I think they're going to discover otherwise. So they may win here or there, but they're going to start losing. And they're going to start losing in court, in part because the law is clear. And they've never extended Section 230 this far. They've never extended other exceptions or exemptions this far, but mostly because the politics has changed. You have congressmen, you have senators, you have the Justice Department, you have attorney generals saying these are bad actors. Now you have presidents from across the political spectrum, left, center, and right, condemning them. They because the courts let them get out of hand, they're like a spoiled kid who finally went too far. And I think not only does Rumble have an excellent case, some questions the damages, but on the low end of their damages, I mean, their point was that they make 40 times more, but for this tying in on the low end. And their argument was they would show up more in other algorithms and other things. But even independent of that, they have at least a $400 or $500 million claim, even if they don't get into the $1 billion category.
And that's
and remember, in antitrust, you get to often, depending on the nature of it, you get to treble damages. So that means you get whatever your damages are, double it, plus you get your attorney's fees.
And that's one thing to appreciate also, is that by shifting the traffic to YouTube, not only does Rumble not get that revenue, but what was the other thing? That Rumble itself runs ads. And so they are being deprived of the traffic that would otherwise generate revenue through their own ads on their own platform if the search results were, in fact, organic, interest-based, and not skewed by one company in favor of the other company that it also owns.
The other great thing it reminded everybody of is YouTube was not a natural monopoly. The YouTube was an artificial monopoly created by Google. At the time that Google bought YouTube, there were 6 or 7 other comparable competitors. It was only because of Google's tying that YouTube ever achieved the monopoly status that it did.
What was I was about to ask one? Oh yeah, sorry. Can you clarify the difference? What is the Sherman Act to the Clayton Act? And I think I understand it. The Sherman Act is antitrust. Clayton sets out specific types of antitrust conduct that is specifically targeted. Is there anything more to it than that?
It should have always been interpreted broadly. No monopolies. Period. That's my. If you read the plain, that's how it reads. The court started gutting it in different ways, and so they provided for specific provisions to make sure certain acts, certain courses of conduct were clearly punished. But otherwise the statutes are read in congruity with one another to meet the ultimate purpose of preventing monopolies, period. In the modern legal judicial environment, it's preventing monopolies that abuse their position of power through things like tying and things of that nature.
And incidentally, in the Rumble lawsuit, but it was also in the Google antitrust lawsuit, which I also did a video on, they specifically talk about the tying that Google requires Android to pre-install and not be able to delete certain apps, and forbids including other apps. So
they use two things. They use their search engine domination to tie in YouTube and create a monopoly there, and abused one monopoly to create a second monopoly. Then they use their de facto monopoly with Apple over apps and over phone systems to create another monopoly, both for themselves and for YouTube. And this is part of what's been documented by the Justice Department Attorney Generals as well. So, I mean, these were, whenever I hear these, Reason Publication, which is really the Koch brothers and Robbie Sove, and who's really just a grifter for big tech. It's all he is. He should be honest about it. Quit lying to the world, pretending he's independent, intellectual. He's just a hack. These are people that, all the Koch brothers, it's the reason why the Libertarian Party is mostly a waste of time. They're mostly corporate spokespeople just in the name of liberty, but it's funny which liberties they come to the defense of. All of Google is not a natural monopoly, and nor YouTube is not a natural monopoly. They have leveraged all of their other monopolies to create more monopolies than existing monopoly power. And that's what happened. And this was not a market outcome. This was monopolistic practices that was in violation of free market principles, not a reflection or expression of it.
Okay, amazing. So, and everyone stay tuned because I'm going to do a breakdown of the lawsuit. I don't know if I'm going to get an interview with Chris Pavlovsky, the CEO of Rumble, not because I couldn't get one, but I don't like talking with parties during pending
litigation. Yeah.
So let me bring up one chat because it's an interesting question. Jason L. Why has nobody approached this from a human rights angle? Free speech has been affirmed to be a human right by numerous international agencies, agreed to by many nations, including U.S. and Canada.
It has been in Europe on right to privacy and other grounds. What it is we just don't have any enforceable human rights laws in the United States beyond what the civil rights laws that exist, and they only apply to state actors. That's why. All
right, and I think we've covered Rumble. It's actually, stay tuned because there will be follow-ups for certain, and it's going to be an interesting suit. It's great. So if you haven't seen it yet, I put up an overview today.
Two great opportunities, the two best opportunities to take on big tech other than the antitrust claims brought by the government.